He's a passenger in the car, and they charge him with criminal trespass. And in the DIMS, it says that he doesn't even know the driver.
In a January 2025 court case, a defendant faced criminal trespass charges for being a passenger in a stolen vehicle. With no clear evidence, he knew the car was stolen. According to Texas Penal Code Section 30.05, criminal trespass requires knowingly entering or remaining on property without consent, with intent, or notice. The judge scrutinized the prosecution's case, noting the absence of direct evidence proving the defendant's intent or knowledge of the vehicle's status. This careful review protected the defendant from an unjust charge, highlighting the judge's commitment to fairness.
Good morning, Mr. Sarmiento.
Ese es señor Sarmiento. Bien, señor Sarmiento.
You were charged with criminal trespass. You were facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney appointed if you cannot afford one.
Yes, Judge.
I'm going to go slow.
Yes, Judge. On January 5th, 2025, the officer became aware of a stolen vehicle via a flock alert. The flock alert was for a listed stolen blue Hyundai. The officer checked the vehicle's license plate and observed the vehicle stolen as of December 21st, 2024. The officer observed the vehicle turning northbound onto East Tex Freeway, taking the ramp heading north on East Tex Freeway, and ran the license plate, confirming the vehicle to be stolen. A traffic stop was initiated. The officer announced themselves as HPD while giving command to turn off the vehicle and place hands out of the vehicle. The defendant, the front passenger, was the last to exit the vehicle, and the officer made contact with the complainant, and the complainant stated he did not know the defendant, did not give the defendant authorization to operate the vehicle.
What?
So they found the stolen vehicle, Your Honor.
How does he know that it was stolen?
And Your Honor, there's no need for him to know this vehicle. There's no requirement he knows, only that he's in the vehicle without permission from the owner. And the owner said he does not.
How does he even know that the person driving stole the car?
Well, he doesn't know the defendant. He doesn't know. He didn't say he know he's stolen. He just didn't know him. Did not give permission.
So you're telling me that he's in a car, he doesn't know the driver, and
Right, the complainant just said that in regard, he did not know the defendant, did not give up.
I understand that. I get that, but so he's a passenger in the car, and they charge him with criminal trespass. And in the DIMS, it says that he doesn't even know the driver. So how would he even know that the car is stolen? How do they know each other? I'm beside myself. I don't. When a criminal trespass requires some kind of like notice that, hey man, you know,
So the trespass was the driver driving into the area, and he was this kind of.
He's the passenger, right? I would assume that the driver got charged with UUMV.
Let me see what he got charged with.
If you tell me no, I'm gonna lose it. Really?
Yes, Judge, UMB.
Okay. But the problem is that like, how would he know that the car is stolen? Right? You got to give me something that it's a specific intent crime. You have to, you know, there's got to, in my opinion, you've got to somehow know that the car is stolen. And
Your Honor, first, I guess to get to that, he was in a relationship with the defendant who was in the vehicle, and there were signs of damage to the vehicle that the officer articulated, saying that there was. One moment.
A scratch on the hood?
Signs of theft that would lead a reasonable person to believe the vehicle was stolen, as the steering column was broken in a manner that only a screwdriver could turn the vehicle on, and the screwdriver was tagged into the evidence. So there was damage from a screwdriver in the vehicle indicating that it was stolen, and this defendant was in a relationship with the driver of the vehicle. And then furthermore.
Did you just tell me that they didn't know each other?
No, the complainant does not know the defendant.
Oh, I thought you also said that the driver and.
No, Your Honor, it may be misunderstanding because of me, but it's the complainant saying he does not know this defendant and did not give permission to the defendant to operate the vehicle.
So there's enough there that a reasonable person would believe
That
he's in a stolen car.
Stolen, yes.
So the steering column, was it?
Was broken, and the officer said that in a manner only a screwdriver could turn the vehicle on.
Un desarmador podía apagar el vehículo.
See, I don't know, because when I was young and dumb and 17, and, my friend had a CJ7, you ever been in those Jeeps that are just jalopy Jeeps, right?
Yes,
They
yes.
always broke down. They always had a problem. We always, Jimmy rigged it as well,
In this case, Judge, I believe there would be enough for PC because we have a vehicle with evidence of breaking into the vehicle with that damaged steering column.
I've been in vehicles like that before.
And we furthermore have a complainant saying he doesn't know the defendant in the vehicle.
No difference.
That goes to the element of for the criminal trespass, it goes to with knowledge that it was,
Nah, no. I'm sorry. I'm gonna find no probable cause. I'm sorry.
Que no hay razón probatoria.
Be careful. When you hang with dogs, you get fleas. I don't know what your status is in this world if you're in this country with permission. But if you go to jail and you're not in this country with permission and you spend any kind of 4+ hours in there, immigration will put a detainer on you and you will be stuck like Chuck in there until you get shipped to immigration. So live like a halo, especially if you're not well documented in this country. Go ahead, take a seat for me, sir.
In the case of Miss Eldridge, the judge carefully evaluated the officer's claim of probable cause after a theft report led to the discovery of suspected Mexican Xanax in her purse. The Fourth Amendment requires that searches and seizures be supported by probable cause, particularity describing the place to be searched and the items to be seized. The judge's decision to proceed with the case was tempered by skepticism about the officer's assertion that the pills were illicit-based solely on experience, highlighting a commitment to fairness.
So, Miss Eldridge, we're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you. Okay.
On March 23rd, 2025, at approximately 3:05 p.m., officers responded to a theft at Nordstrom Rack. The officers gave a description of the vehicle involved in the theft, and the officer located the vehicle, which was occupied by a male and female. The officer asked the defendant if she had any property inside the vehicle, and the defendant stated that she had a purse. The officer asked for consent to search the purse, and the defendant granted permission. The officer located a bottle of what they knew to be Mexican Xanax, which was approximately 9 grams. The defendant stated that she had a prescription but was not able to produce it. Based on the circumstances and the defendant's previous drug charges, the officer believed that she did not have a prescription.
May I respond, Your Honor?
I don't understand.
Sorry?
Were they just in the street in the car?
They were inside the vehicle that was identified by the as the vehicle for the theft. So
I guess I missed it. There was a theft.
they were dispatched to Nordstrom for a theft.
Okay.
They went to Nordstrom. They were advised that
Those are the people.
to give a description of the vehicle that was involved in the theft. They located the vehicle. They were found at the vehicle.
Anyone
Your
else?
Honor, if I may, Your Honor.
Shh. Say it again?
Can I say something real quick, Your Honor?
Yeah.
I mean, there's no description of the vehicle. I mean, there's not specific articulable facts here. Just a white vehicle. We saw a white vehicle. We pulled it over.
And
No description of the people in the car.
It was
I'll have her read it for you.
a black 2015 Hyundai passenger car bearing Texas license plate KZD 1788.
Okay.
So we did have a description and a
We have a
license
good
plate.
description of the car. Did anyone get arrested for the theft?
It doesn't look like anybody was charged with that. I don't have a could have been in you.
Okay. Ma'am, I'm gonna find that there's sufficient probable cause to go forward with your case. I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, unprescribed controlled medication. I'm going to randomly test you. If I find that you're using, it's not gonna go well for you. Do you understand? So what should we do about bond, guys?
Well, Judge, so she tells me she does have a prescription. It's from Scott's in Midtown. What I found was Scott Reed's Pharmacy. There is one
It's
on
Mexican, man.
How does the cop know that? Really?
He said it's Mexican, Sam.
Yeah. Okay. How does the cop know that?
Huh?
The cop sees a pill and goes, "Oh, this is from Mexico," or "This is in a lab."
This is based on previous work experience, Judge. So,
Yeah. Well.
I mean, go see what you can get, I guess, right? And then,
All right. Well, we'll
well,
do
I need
the-
to set a bond, no bond right now. So I gotta set.
Okay, I'll do a motion inspect evidence when I have time, and we'll go.
Yeah,
But that being said, Your Honor, she has a $10,000 bond on the felony that was set, and there's a chance she might have a script for this, and she says that they actually should have records of the.
What should we do about bond?
I mean, I would ask for. She's got a 10,000. I would see if the court would do a PR bond on this one. If there's she has to make the felony bond, and there's a chance she does have a script for this. She shouldn't even be in custody on this if that's true.
She was in absconded status as far as the felony is concerned. I think that she's a flight risk. So,
Well, and may I say something on that too, Your Honor?
sure.
On the MAJ, so she tells me she was reporting. She got switched probation officers. Again, I don't know the veracity of this. I'm just relaying, and so I'm showing that the address that was last reported. This is what they're claiming. MAJ as well was San Leon, Texas. So, I don't know if there was a mix-up in that where the probation, office was. And I don't know if that may have, so I'm just throwing that out there, that may have been part of it.
What do you think for bond?
Judge, we depose any PR bond. We'd ask for a security of any amount at your discretion.
Okay, so what I'll do is I'll set bond at $1,500 surety.
Okay.
Okay, I'm not going to grant you a PR bond. I think that you're a flight risk and you're on felony probation. Regardless, you've not made the $10,000 bond upstairs. If you're able to make bond, we can come back and talk. But if you do, it's extremely important that you maintain contact with the lawyer here.
Yes, sir.
Because if you don't, another warrant will issue here and it's just going to balloon and just get out of control. Okay? It looks like you have felony court on the 9th
Yes.
of next month. So what we can do is we can set you on the 10th, the following day, to see what happens there. We can't set you the same day, but we'll set you for the day after, and then we'll figure out how to go forward at that time.
Okay.
Oh, I don't know.
I can get on in the morning, Zoom, Your Honor, on the 10th.
Are you sure?
Yeah, it's fine.
Okay, so set it for the 10th and he can zoom in at that point
Okay.
for this case. And then, so I'll set bond at $1,500. Okay, ma'am, good luck.
But yeah, she has a friend that might be making bond. She doesn't know yet. So if that plays out, obviously she's going to pop up here before.
Just come back and we can talk.
Okay,
You know?
thank you.
She needs to sign conditions.
By setting a reasonable bond and allowing for further investigation into Eldridge's prescription claim, the judge protected her rights against potentially overzealous policing. The judge's refusal to grant a personal recognizance bond, citing Eldridge's absconded status and felony probation, demonstrated a balanced approach to public safety and individual rights. Under Texas Code of Criminal Procedure, Article 17.01, bail is set to ensure the defendant's appearance while considering the nature of the offense and the defendant's circumstances. By setting a $1,500 bond and scheduling a follow-up hearing, the judge provided Eldridge an opportunity to prove her prescription claim while maintaining accountability. This careful oversight curbed the risk of unjust detention stemming from the officer's unverified assumptions about the medication's origin. These cases reveal how judges can uphold justice by challenging flawed charges and ensuring fair treatment. By dismissing baseless cases and setting strict bond conditions, the judge safeguarded defendants from systemic overreach. This commitment to fairness strengthens trust in the legal system, protecting the innocent from unjust prosecution. Like and subscribe for more police cam stories. Watch the next recommended video. Click to watch now.